We're going to talk about liens, all different types of liens, and what we'll define is what is a lien, who has a right to claim a lien, and what are they claiming the lien on. So starting with what is a lien is quite simple. It is a claim for monies that the injured party is entitled to. It is not a claim to the totality of the resolution of a case. And we've already talked about, and I would encourage you to watch, what is the value of a personal injury case. That'll inform you as to where we come up with what the value of a case is. And this is a little more specific. Liens relate only to a client's share, an individual's share of the total amount. And the reason for that is quite simple. The individual, the injured party, received a benefit, and the benefit that they've already received was paid by somebody else. And in law, there is no such thing as a double recovery. So those who provided the benefit want to receive the monies that they've already laid out. And liens come in all different forms. There are medical liens, and we're going to talk about that shortly, but it's important to understand it's really a repayment for benefits that have already been received by the injured person. They are not forward-looking. They're everything that's happened in the past. So liens come in really three different types. There's what is called a statutory lien, a contractual lien, or what I call a claimed lien that is not valid. And most attorneys don't include the third portion because in reality they aren't a lien at all, but I do want to address them. So that's why I say there's three different types. So a statutory lien is a lien that is by operation of law. What do I mean when I say by operation of law? That means that there is some statute or law that automatically says if an injured person recovers monies from a personal injury lawsuit, then they are automatically entitled to recover those monies back that they've outlaid. Why is the automatic component of that important? Because there's a notice requirement. If an attorney who is responsible for honoring the lien or an injured person who is responsible for honoring the lien, if they are not put on notice of the claim for those monies, then they are not responsible for them. However, with statutory liens, notice is not required. You are presumed to know about this lien, and the burden is put on the attorney and the client to notify that potential lien holder of the claim. So, as a simple example is Medicare. Medicare has a statutory right to repayment of those Medicare benefits that have been paid that benefit the client during the course of a litigation, from the moment of the event until the time of the resolution. Medicare is not required to send a letter to the injured party, the claimant, or the law firm. The burden is placed on the law firm to affirmatively reach out and determine, is there a Medicare lien? And if there is, what is the full extent of it? And a negotiation occurs, which we'll talk about shortly. So a statutory lien is by operation of law, and it's automatic. It can't be ignored. The attorney who represents an injured party is responsible for paying that lien, for discovering that lien, and if they fail to do so, the law firm and or the individual lawyer is responsible for paying those monies, even if those monies have been dispersed to a client. So lawyers and law firms affirmatively reach out and determine which liens are outstanding when they are statutory liens, and there's several of them. The other type of lien is a contractual lien. This is a lien where an individual, an injured party, actually enters a contract with a medical provider either after an event occurs, or there could be a contract that's already in existence, which is often a health insurance contract that says, and I'm going to separate those. First, the health insurance contract. A health insurance contract may say, they don't always say, may say if we pay medical bills that come as a result of a tort, whether it be a car crash, a fall down, or any type of event where you are injured and it's a result of somebody else's fault, and you pursue compensation to recover for those injuries, you're obligated to do two things. One is also include in your claim a recovery for the medical bills that they have paid. And secondly, if you do recover, pay those medical bills back. That is a contract that you've entered into with your health insurance provider. Now, this is all a hypothetical because each health insurance contract is different. So sometimes there is a lien, meaning that those monies that they've extended to for your medical care have to be repaid, and sometimes they do not. The contract also defines the notice provision. The contract places often the injured party, their responsibility is to notify them that they are in fact seeking reimbursement from the person who caused the underlying injury. The law firm generally does not affirmatively reach out to health insurance companies to discover if in fact there is a lien, because it is not a statutory lien, meaning it is not an automatic lien. There's a notice provision oftentimes where the lien holder, the person who is claiming a portion of the injured person's monies, the lien holder has the responsibility to put the law firm on notice. And if they fail to put the law firm on notice, the law firm at the end of the case obviously is unaware of the lien and would disperse those monies to the injured party and does not have a responsibility should that lien appear after the resolution of the case, does not have a responsibility to pay it because those monies have been provided to the injured person. However, that does not extinguish the injured person's responsibility to repay those monies. And if the insurance company, the health insurance company, or the lien holder discovers that there was in fact a case and a recovery, they have the right to pursue those monies and a refund from the injured person because they've collected and failed to notify the health insurance company of their recovery. So that is a contractual lien. Those liens that are the contract that's in place before an event happens, or sometimes the lien is created, a contractual lien, after the event happens. There are several medical providers, if there is no insurance available, or the insurance company has denied the payments, the medical provider is willing to continue those medical treatments, provided the injured person agrees to repay the medical provider at the conclusion of the case. And a simple lien document, which is really a contract, says that the injured person acknowledges that they are receiving medical care, that the health insurance has denied payment to the doctor, but the doctor agrees to continue treating the individual, provided they will sign that acknowledgement. That acknowledgement is then sent to the law firm. And at the conclusion of the case, the monies that are recovered are then, a portion of them are paid to satisfy that medical lien. Oftentimes, injured people have no other way of getting treatment, and many doctors are kind enough to provide that treatment on a lien. And each case is unique and has to be evaluated with the attorney, but it's certainly an option. And that is a contractual lien. And the third type of lien is what I call an invalid lien, where anybody makes a claim that they have a right to a portion of the client's recovery, but they cannot show that they have a statutory lien, meaning that by operation of law, they automatically have a lien, and they are not able to produce a contract that says that the client, the injured person, has agreed to pay a portion of their recovery to that person. It may sound odd, but there are times when landlords will claim a lien, or business associates will claim a lien where they learn that somebody may have a personal injury case, and they write a letter to a law firm and say, I want a portion of those funds. Well, unless they can provide an actual contract where the injured person specifically agreed that out of the proceeds of any recovery that the lien holder would be paid, that's an invalid lien and would not be honored. So the different types of lien holders generally are the government. The government has made a decision to be actively involved in personal injury cases through Medicare and Medicaid. Medicare is a basically health insurance coverage for a select group of people. Individuals who are qualify and have been granted Social Security disability automatically are eligible for Medicare. Or they've attained the age of 65 and are Medicare eligible. But just because an individual is Medicare eligible does not mean that Medicare has paid any monies as relates to the underlying injury from the personal injury case. So the law firm has an obligation to reach out to Medicare for anybody who is Medicare eligible to confirm that Medicare does or does not have a lien. There are multiple ways to work out Medicare liens, and it's a little too complex for purposes of this video, but there are things called a Medicare set-aside, which basically sets a certain amount of money aside from the lawsuit. This is done in agreement with Medicare, and all of those monies are used for payment of Medicare eligible benefits, whether it's pharmaceuticals or surgeries. And once that Medicare set-aside is exhausted, the individual is automatically qualifies to return to Medicare. If it is determined that there is a personal injury case, that somebody received monies and did not properly notify Medicare, Medicare can stop the Medicare benefits, and you are not eligible until you go through a significant undertaking to prove that all of the monies that would have been used for Medicare were in fact used for medical benefits. It is a situation that nobody wants to undergo, and frankly, we're required to notify Medicare, and it should never happen. The other state health insurance entity is Medicaid. Medicaid is also a statutory lien, but the distinction with Medicaid is it is a local state provider, and often it's the county, frankly, and it's a negotiation with the county as to what is reimbursable, what actually is part of the lien. Just because somebody may have received Medicaid benefits doesn't mean everything that was paid by Medicaid is lienable, meaning the state or the county is not entitled to 100% of their monies back. They're only entitled to those monies that have been paid for injury-related care. So hypothetically, if somebody has diabetes and they're receiving diabetic treatment and they're involved in a car crash, or they fall down is a better example, and they fall down and they break a bone and they receive Medicaid benefits for the fracture of their arm, then Medicaid is only entitled to recover for the medical bills paid for the broken arm, not for all the diabetes and the diabetic care. So there's an undertaking that's required to determine what is accident related and what isn't, and negotiation occurs with Medicaid. Health insurance is another, they are not statutory. These are contractual liens, but some are automatic and some are not. If it is an ERISA, and ERISA is a federal program where basically a health insurance company must do certain tasks to be an ERISA approved plan. But if it's an ERISA approved plan, then it becomes a statutory lien, and it must be paid back. If it is not an ERISA approved plan and it's private health insurance, then those, whether the insurance plan is entitled to repayment as a lien or not, is contractual, and it all is determined by what the underlying health insurance policy says. So they are all contractual, but some are elevated to, in essence, statutory liens. Car insurance, in most states, in New York and New Jersey, when somebody is in a car crash, and I encourage you to watch the video about the basics of personal injury law where I address car crash, and another video I've done with respect to no-fault insurance, whether it's New York or New Jersey. They are a bit different. Either way, if somebody is in a car crash and they are involved with another vehicle that also provides what is called no-fault insurance, or PIP, personal injury protection, which is really just the medical benefits in the car insurance policy. When somebody is receiving those medical benefits, they are not lienable. There is no repayment to the health insurance side of a car insurance policy. No fault does not have a lien, but this is where the twist, I'll define it as, comes into place. No fault does not have a lien for their basic economic loss. So for example, in New York, there's every car has $50,000 of insurance. In New Jersey, most have $250,000 of insurance, but some individuals may pay for additional benefits over and above that basic economic loss. As a simple example, if everybody has $2,000 in New York State, 80% of your lost wages, up to $2,000 a month, up to with a maximum of $50,000 of payment. That amount, the no-fault insurance company, even if you recover from the person who caused the crash, that no-fault insurance company is not entitled to any of those monies back. They are not lienable. However, if you purchased additional personal injury protection, additional no-fault coverage, and instead of the minimum $2,000 a month, you purchased an additional $2,000 a month for a total of $4,000 a month, the first $2,000 is not lienable, but the second $2,000 is a contractual lien that is automatically required to be repaid. So there are some nuances whenever dealing with car crash cases, or frankly with any liens. There's always nuances, and the purpose of this is just to give a broad overview of trying to take a little bit of the complexity out of liens. And I hope I'm satisfying making it simple. So another type of lien holder are union benefits. That too is a contractual lien, and it is governed by the union contract, and each one is different. But if it is an ERISA-based union contract, then there will automatically be a lien. If it is not an ERISA-based contract, then it's determined by the actual contractual language, which is why the law firm would be asking for that contract. Another common lien is workers' compensation. And I've done another video describing on-the-job injuries, when you're entitled to workers' compensation. And I'd encourage you to watch that as the foundations of the interplay between workers' compensation and personal injury lawsuits. This is limited to discussing the workers' compensation lien. Now that is a statutory lien. It is an automatic lien that the recipient of workers' compensation benefits must repay if you recover from a third party, which I define in the other video. But a third party in substance is the entity or individual that caused the injuries, as long as it is not your employer or co-employee. So the way a workers' compensation lien operates is workers' compensation provides both medical benefits and lost wages, if they exist, and they never have to be repaid unless there's a recovery from a tortfeasor. When there is a recovery from a tortfeasor, it's automatic that that lien is in existence, and then a negotiation occurs. Because the injured party has brought the lawsuit, and somewhat for the benefit of the workers' compensation carrier, the workers' compensation carrier does not get 100% of recovery of what they've outlaid. They get there's an automatic reduction of at least 1/3, because the injured party is paying a legal fee to recover that, and the workers' compensation carrier does not get the benefit of that. So the payback is automatically reduced by 1/3, and then there are often further negotiations where the lien can be further reduced and oftentimes extinguished. And there's some unique situations where because the workers' compensation carrier is getting a benefit, and let me define what that benefit is. Workers' compensation carrier, once a injured person recovers from a third party, the obligation for the workers' compensation carrier to continue those workers' compensation benefits, they cease, they stop. The workers' compensation stops when there's a settlement or a resolution in a third-party case. Well, they don't stop forever. They stop until what the equivalent of those future workers' compensation benefits would have been are exhausted. And let me just give a very simple example. If somebody was receiving $100 every week, and their net recovery in a personal injury case was $400, then workers' compensation would stop for 4 weeks if the individual has a permanent injury. There are a lot of subtleties to this, but this is really just for illustration. So after those 4 weeks, the person is then eligible to return to workers' compensation. Well, that is just such an unrealistic example that I gave, but I wanted to illustrate the concept that there's a window of time that workers' compensation would stop, and then a window of time that potentially that somebody would be eligible to return. So there are times where that is a tremendous benefit to the workers' compensation carrier, that we can negotiate that they, rather than become eligible sometime in the future, they will not only extinguish their lien, not recover anything, but they will agree to put in what we call fresh money over and above what the settlement with what's called the tortfeasor, the negligent parties insurance. So when it comes time to resolution, there are a lot of moving parts that have to be considered whenever there's workers' compensation involved. Another type of lien holder is a medical provider, and I discussed that a little bit earlier, that if you are receiving medical benefits and the health provider, whether it be workers' compensation, has said that you've reached maximum medical improvement and won't provide future care, or the no-fault carrier for a car crash case has sent you to a defense medical exam, which I would encourage you to watch that video, which I did. I did a whole explanation as to what is a defense medical exam and what to be on guard for. But workers' compensation or no-fault insurance may send you for a defense medical exam, and if those medical providers that they hire in fact say an individual has reached maximum medical improvement, another way of saying that is their belief is future medical care will not benefit the individual. The subtlety to that is it allows them to say you're injured and the injury's bad, but there's really no benefit of future medical care. And that allows them to cut off future medical care, even though we all know you truly would benefit from it. That doesn't mean that you have to stop those treatments. If your doctor or medical provider, whether it be a physical therapist, chiropractor, or anybody in the medical field, if they're willing to continue that treatment, you can enter a contractual lien whereby you say, I have a lawsuit. You can contact my law firm and they will tell you about the merits of the lawsuit. There is confidentiality involved, so you have to give us authority to speak to your medical provider, but we will share with them what our expectations are with respect to the underlying case. And if they are willing, you can sign a simple document that says at the end of the case, they will be paid out of the proceeds, and we will seek to collect all of those bills as well. So that's a medical provider lien. And then lastly, what's becoming more and more commonplace are what are called funding company liens. And you'll see another video with respect to funding companies, which I go into detail with respect to them. But in short, a funding company lien is where an individual enters into a contract with a company that allows them to get advances on a future resolution of their case. Those are contractual liens. You sign a document that acknowledges and authorizes the law firm to pay out of the proceeds of the lawsuit directly to the funding company. I do want to highlight and that all of these monies that we are describing really are your monies, the injured person monies, because you've already received the benefit of these. And when it comes down to, at the end of a case, if the legal fee is 1/3 and a case resolves, easy numbers, $90,000, 1/3 of 90,000 is 30,000, 2/3 is 60,000. The 60,000 is the injured person's portion. That is the portion that the medical lien comes from. Because you have already received the benefits, that's where the lien is repaid from. And I want to highlight one component of liens that often people don't realize. And it is the responsibility of the law firm, an obligation of the law firm when dealing with liens. And this is a unique position lawyers are in, because lawyers are actually in a quasi-conflict situation, because we owe a duty of loyalty to our clients and to represent our clients zealously. And our first and obligation is to our clients, and we revere that obligation. But when a third party, somebody else, makes a claim to monies of our clients, we have an obligation to that lien holder too, not to compromise their interest. That doesn't mean we prioritize their interest over our clients, but we have an ethical obligation not to compromise those interests. So as an attorney, our obligation is to learn what liens actually exist, which are the statutory liens, as well as which are the contractual liens we've been put on notice of. What we don't have an obligation to do is scour the world to find any potential lien holder. If they had the obligation to put us on notice and they failed to, that is not the law firm's obligation. It remains your obligation as an individual, and they can pursue a future claim against you if you're aware of it and did not disclose it to the law firm. So you should be aware of that. But the law firm doesn't have an obligation to go out and find liens, contractual liens, that we were not put on notice of. But for all liens we are aware of, the statutory liens and contractual liens we've been put on notice of, we then have an obligation to honor that lien holder's position. However, we do discuss it with our clients, because if you have a position that is contrary to the lien holder, we don't simply just hand the money over to the lien holder. Then there's an issue. So in that scenario, we'll negotiate with the lien holder and ultimately try to reach a resolution. But if we can't reach a resolution, we have an obligation to keep the full amount of the claimed amount by the lien holder in escrow. We are allowed to, and we do, give the balance, everything over and above the claimed lien amount, to our clients, but we have an obligation to keep that total amount of the lien in escrow until it's resolved. And we continue working on that resolution. So the underlying message and the bottom line is lien holders have legal interests to monies, whether they're actually recognized or not, may slow up receiving all of the monies that you're entitled to. So that's a very broad overview of liens, the different types of liens. I hope it was informative, and I appreciate any feedback that you may have, because I'm happy to supplement this if there's something that you feel would be beneficial.